Attorney Greg Dell here with attorney Stephen Jessup, and we're going to talk about long-term disability insurance appeals and denials against the Guardian Insurance Company. Guardian's certainly not one of the top 5 largest group disability insurance companies, but they write a fair amount of policies across the country, and they usually write a decent long-term disability policy. But when it comes time to respond to a denial, it can be one of the more challenging denials just due to the depth of experience of the claims handling people at Guardian when they actually do submit a written denial letter, as opposed to a Prudential or a MetLife, Cigna, Unum, who kind of mass produce denial letters in long-term disability insurance claims. So I want to start off, making the assumption that a person's watching this video because they've recently been denied or fear they're going to be denied on their Guardian claim, and want to give them some tips about how to handle a claim, how we would help them, and just from the start, how do you get started with an appeal, and then working through what our goals would be in that appeal to get them into a position where they could possibly win their appeal. So let's start with the first steps from when you receive a denial letter.
When you receive your denial letter, I think first and foremost, the most important thing anyone can convey is don't file an appeal right away. Sometimes people say the claims examiner said you just have to write a letter explaining that you disagree with the decision, and that's sufficient for an appeal. So don't do that, because with Guardian you're only going to get one opportunity to appeal. Obviously, if you're watching this video, we would recommend you speak to an attorney, because your legal rights, your financial well-being into the future are really tied up in this one appeal document. So, consulting with an attorney to discuss the situation with regards to your claim. You can even be so proactive as to request a copy of the claim file from Guardian, and they'll turn over everything they have that you've either sent them or they've created for the purposes of reviewing your disability claim.
Okay, so when we get this claim file, which we'll request on behalf of the claimant, what is it? What are you looking for in there? And how does that shape our plan of attack to try to get benefits reinstated?
The most important information in the claim file, it coming from Guardian, will certainly be their medical reviews and their vocational reviews. You're also going to have all of the internal notes, correspondence, your medical records, things like that. But for purposes of the appeal and really setting up a plan of attack to win your benefits back, it's going to be looking for the medical reviews that they performed, those occupational reviews, whether they're determining what your job was, or if you're in that any occupation stage, other occupations they think you could do, and if there's been any type of video surveillance done. Guardian isn't really known for video surveillance like some of the other insurance carriers, but they certainly will employ it if they think it'll help in their review of your case. So those are the big ticket items that you're really looking for to be able to shape the next steps.
So the claim file can be anywhere from 500 to 15,000 pages.
They can be massive. Depending on the age of the claim, the information, they can be quite large.
It really takes a long time to dig into it, go through every single thing, which is fairly routine, in our practice. And then we sit down with a team of at least 2 lawyers and a paralegal and put a strategy in place. When we're sitting down and doing that, talk about the calculated kind of coordinated effort that has to come through with the treating physician in terms of to really prove the claim, and how our approach is unique in proving a claim versus anything that a claimant could possibly do on their own.
Well, I think the big thing is going to be working with the doctor. Obviously, if your claim's been denied, Guardian's doctors don't agree with your doctor. So whatever's been in the medical records, the claim forms, up to date, is insufficient, really, or you wouldn't be in this position. So it's really getting into those medical reviews and seeing what Guardian's doctors are saying is lacking, what objective evidence can be added, and then not only coordinating to have certain testing potentially done, but really in working with the doctors. And sometimes people just give the attending physician statement to the doctor and say, hey, can you fill this out? The doctor fills it out and they submit it without really addressing the things that need to be addressed to appease and to counter the opinions of Guardian's doctors. So it's working with your doctor. This isn't just purely about your medical condition, and this is really kind of like forensic medicine in the sense that you are trying to prove your condition is disabling, so there's a legal element to you. So it's really working hand in hand with the doctor.
So very often what we do is we do custom attending physician statements, not the one that the company sends. That's 1 or 2 pages with little lines. Can you sit? Can you stand? Can you walk? Can you lift? All that stuff. We got very specific. We dial in the details, and that's custom to your condition, your occupation, your definition of disability. And those are, in our in the terms of how we draft them. They could be 3 pages, they could be 10 pages, and we try to make them as easy as possible for your doctor, and we let the doctor know that the doctor is going to get paid for that time to do that. It's very hard for a claimant to just approach the doctor with some kind of form, let alone the claimants don't know the way the form should be drafted and things like that for what the disability insurance company is looking for.
And also with those forms too, I think a lot of doctors sometimes feel hesitant wanting to get involved with an insurance company. They think, if this ends up in court, am I going to be deposed? Am I going to have to testify? Is this going to be a hassle? So even in some, sending over those forms to be completed, advise the doctor, that the policy is governed by ERISA. You're not going to be called upon to testify in trial. You cannot be deposed. That if this ultimately goes into court, a judge is only going to be able to consider your written, opinions, whether in your medical records or these forms. So kind of ease the doctor's mind that this won't be a huge drain of their resources and time.
That's a good point, because also we're using that statement from the doctor as basically their deposition, their testimony in front of the judge, because there will be no further testimony if the case isn't won. The other thing we do very often, and since we have 6 months to file an appeal, is we guide the claimants to get better objective evidence. Because every denial says, well, we see your subjective complaints. You have pain, you have limited range of motion, you can't sleep. Whatever it may be that you're saying is why you can't work. But there may be very good objective testing that we will guide you to get, whether it's additional MRI, CT scan, X-rays, EMG testing, blood work, functional capacity exam, our own independent medical exam. There's a whole variety of what I call tools available that your treating doctor may not need to use, but we have used, and we recommend your doctor refers you for these tests, because Guardian's expecting to see that information, and your doctor doesn't need it to treat you. Your doctor treats you, it doesn't treat the chart. And so that's the big distinction here when you mention that word forensic versus medical care. The forensic evidence that we're looking for is not what the doctor needs to treat you in your claim. The other topic I want you to just touch on is like the art of how we write our appeal versus lawyers who aren't that experienced in this or just very aggressive and want to throw case law and all those things. What's the strategy in how we write our appeals to protect them if a lawsuit had to be filed?
First and foremost, the appeal, the heart of the appeal, the true purpose is to prove that the medical condition results in disability as it's going to be defined in your policy. So the evidence, that medical information, that's the teeth, that's where the success is going to lie. Being able to address deficiencies in the medical records and be also to counter those of guardians. In a situation where you throw out lots of case law and you're telling them everything that they did wrong from a legal perspective, you've now given Guardian a roadmap to say, well, you said we should be doing X, Y, and Z. We did X, Y, and Z. They uphold the denial, and now when you're filing a lawsuit, you've now lost all those legal arguments. And why that's important is in the vast majority of these cases, there's some instances where it's not going to happen, but the vast majority of these cases in court is going to have that arbitrary and capricious standard of review, where the court's not tasked with determining are you just disabled. They have to find you're disabled and then show that Guardian acted unreasonable. They didn't have a reasonable basis to deny the claim. So it's this fine balance of not telling them everything they did wrong, because if you do and they correct it, they say, well, Judge, even if you disagree with us, we're very reasonable. We were told what we did wrong and we addressed all those things and we still came to this conclusion. So the heart of the appeals that we write is really, really married with the medical and presenting the medical information. A lot of certain other things that we add in the appeals, like personal statements. I'm not so confident Guardian is going to read those, but that's also another way, like you said, with no testimony in court, to have the client testify to the judge. But at the end of the day, you're as strong as your medical file.
Okay, so a couple important things for you to understand. Number one, no matter where you live in the country, we can handle your appeal and we can handle your lawsuit because they're all in federal court, and we can go in any federal court in the whole country. Probably most importantly, which is very important for clients, is we don't charge you any fees or costs unless we're able to recover benefits for you. So if we submit your appeal and we lose your appeal, there's no charge. No matter what we spent on your claim, you'll never owe us any money. So that's a very important fact to know, that you don't have to sit there and say, how am I going to come up with tens of thousands of dollars to compensate this law firm for the bunch of time that they're going to put into this case. You don't, because we're going to work out a fee schedule with you that's a percentage of whatever you end up recovering from your benefits. So we always offer a free initial consultation. It's very easy for you to click the free consultation, claim on our form, which will email us and we'll call you or set an appointment. You can call us right now. One of our lawyers will take your call. We're going to ask you to send us the denial letter that you've received. We'll review that. Based upon our experience, it takes us a matter of minutes to review the claim and have a general idea as to whether or not we think we could help you. Always a free consultation. We thank you for considering us, and we look forward to the opportunity to discuss your claim with you.